Okay, let's get started on our final topic in the criminal justice process, at least so far as we're going to study, which is punishment or sentencing, right? So, after a defendant has been convicted, either by a jury trial or a bench trial or by pleading guilty, then we are in the position of trying to determine what the sentence will be, what punishment will be imposed on the defendant. So, we have finished the adjudicatory process and we're now in the sentencing phase. So, the three topics covered in this recording include some incarceration data and statistics in order to give you some sense of the big questions that surround punishment or sentencing. We'll also then take a look at punishment theory, which should undergird all of our statutory approaches and practical applications of sentences or punishment. And then finally, we'll take a look at a number of cases, and I'll present to you some problems that help you look at punishment in application. So, how do courts actually fashion sentences on the ground? Okay, so to begin with incarceration data and statistics, the chapter opens by providing you with food for thought about incarceration in the United States. In the United States, for violations of serious crimes, incarceration is the usual form of punishment. At several points during the semester, I've mentioned the legal phenomenon of overcriminalization that has occurred in the last several decades. With respect to punishment or sentencing, we have also witnessed a related yet distinct legal phenomenon. This one we call mass incarceration. And the data helps us understand this particular phenomenon. Next slide. So, at least as of 2016, we were incarcerating more than 1 million people in the United States. And while this data is a few years aged, I will tell you that it is still quite similar. Next slide. As of the time of this data, the United States was incarcerating at the highest rate worldwide. And certainly, we are the highest among our peers, far outstripping, for example, Australia or Canada or France, right? Countries whom we consider to be our equals in many respects. Next slide. This chart reveals to you that most individuals in federal prisons are there for drug offenses, and that most individuals in state prisons are there for violent offenses. And so you can see at least that there are different types of crime driving incarceration rates, whether we're looking at states or the federal government. And so much of the conversation around mass incarceration has focused on the significant number of individuals in federal prisons because of drug crimes. And again, those may not be what you would think of as highly serious drug crimes, drug cartels, or continuing criminal enterprises. There are individuals there for mere possession as well. But that appears to be a significant driver of the incarceration rate in the federal system. And then in the state system, it is that individuals are being incarcerated for violent crimes. Next slide. One of the major concerns about mass incarceration is the disproportionate impact that it has on Black men in America. It is the case that the population of those who are incarcerated are overwhelmingly male, overwhelmingly Black, and overwhelmingly poor. And so this data is particularly disturbing because notwithstanding the rate of incarceration, the rates of offending, particularly between um, men, are not dissimilar. In other words, men of all persuasions seem to offend at similar rates. And so it is difficult to, at times, get one's head around why the rate of incarceration for Black males is much higher than for certainly white men and even Latino men, even though Latino men are facing a significantly high rate of imprisonment. So this data is important to be aware of because it raises many legal, public policy, and moral questions about the criminal justice system, including, is the system legitimate? Do we punish fairly and without discrimination? Do we need to change sentencing laws? Are we dedicating too many resources to investigation and prosecution and corrections, especially in light of economic crises? And should we consider alternatives to incarceration, um, notably rehabilitation? So, I've also posted on Twen two links that reveal some thinking of practitioners and professors and activists on these questions. So, one is a short comment by Professor Angela Davis on racial disparities and the role of prosecutors, and then as well, um, a short video addressing the question, is our criminal justice system broken? So, take a look at those two videos to get some of sense of the thinking of some of the individuals who focus on these topics regularly. So for us to begin to answer these questions, we're going to begin by looking at the moral justifications or the theories for punishment. At the end of this conversation, I do not expect you to become a philosopher. I'm not a philosopher. I have no pretense towards that. And I would expect you just to have a basic understanding of the philosophical underpinnings of punishment. And then we will look at how those theories are actually applied. So take a look at the next slide. We begin looking at punishment theory here. There are two dominant punishment theories, utilitarianism and retributivism. And in this first slide, we look at utilitarianism. All right, this is also called consequentialism or instrumentalism. And here, according to Grunewaldt's concept or theory of utilitarianism, the purpose is to achieve useful outcomes or consequences, right? So as applied to punishment, we're generally trying to achieve four goals listed here in this slide and set out in the reading. So general deterrence, that is to convince the public not to commit crimes for fear of punishment. This is a notion of word to the wise. And then specific deterrence. We want to create fear in the particular offender that if he repeats, he will be punished again. So maybe let that be a lesson to you. Incapacitation, we seek to physically remove from society an individual. Maybe we want to remove them temporarily, or maybe we want to remove them permanently. Maybe we want to remove them wholly by incarcerating them, or partially by placing limits on their abilities to engage in physical movement, so electronic monitoring, for example. And then finally, rehabilitation, right? The goal here is to lessen the desire in an individual to commit crimes in the future by enhancing their future options. So here we are seeking to provide a cure for what ails you. Notice all of these goals or outcomes are designed to prevent future harm or danger to the public. So utilitarians, right, are interested in punishing an individual only so much as would be necessary to produce a positive outcome in the future. So to reduce crime, to prevent future harm. Utilitarians would not punish an individual any more than is necessary. So recidivists would be punished more harshly than first-time offenders, given the thinking that if you're a first-time offender, we will punish you in a way that we think will deter you from committing your crime, a crime again in the future. But if you're a recidivist, if you are already engaging in repeat offending, then maybe we think you need to be punished more harshly. One of the common critiques of utilitarianism is that it allows for punishment of an innocent, if that would benefit the public. A related critique is that we are using people as a means to an end. So for example, we punish one individual in a particular way to deter other individuals. Other critiques include that rehabilitation might be ineffectual. There is conflicting data on this. So can we actually prevent future harm and future offending by rehabilitating individuals? The data is still a little bit unclear on this. And then The final critique that is commonly raised is that in order to punish only so much as necessary to promote future benefits requires the ability to predict future dangerousness, right? How likely is an individual to reoffend in the future? How dangerous will an individual be in the future? That's a difficult prediction to make. That is a common critique with respect to utilitarianism. All right, and so as we see here in the slide, in terms of the actual practical applications of utilitarianism, we get individualized case-specific sentences or punishments, right? They are particular to the individual um, and the particular facts of the case. We allow for a range of indeterminate sentences. In other words, sentencing statutes might say punishment for conviction of a felony is subject to 0 to 5 years. And that allows for um, the judge or the jury in limited circumstances to impose a sentence within 0 to 5 years that would fit the individual or that fits the specific case. As I mentioned before, we do harsher sentences for recidivists. And then finally, utilitarianism on the ground recognizes a variety of different sentencing options. Maybe one individual needs to be incarcerated while another individual can be placed on probation with conditions. So next slide. In contrast to utilitarianism are the retributivists, or those who advocate retributivism. Here, the justification for punishing an individual is that the individual is morally culpable and thus deserves to be punished. So while utilitarianism concerns itself with public safety, retributivism does not concern itself with public safety. Two conditions must exist for a person to be punished under retributivist theory. The individual must be a wrongdoer and must have committed a crime. The individual cannot be innocent. So an individual is culpable and deserving of punishment because the individual has voluntarily chosen to violate the rules of society. They have exercised autonomy and free will. And so we respect their personhood by punishing them. An individual has also violated society's rules, creating an imbalance and thus owes a debt to society. And punishment restores that debt, restores balance. As well, criminals should be hated and hurt or punished. And then we need to right a wrong that has been committed against a victim. We need to reaffirm a victim's worth. All right, so retributivists focus on culpability. All right, retributivists do not necessarily grasp or embrace this idea of lex talionis, an eye for an eye. Right? Under retributivist theory, you may only punish in proportion to what the offender deserves, only in proportion to the offender's culpability. And so that may result in an eye for an eye, but most modern retributivists do not believe in an eye for an eye. Also, keep in mind that retributivist punishments are present focused. They are not based on remediating any concerns for the future or any concerns for future public safety. And as well, keep in mind that the amount of punishment is not individualized, right? It's not based on the defendant's particular characteristics or criminal history. It's focused on the culpability. What particular crime did an individual commit and what is the individual's culpability? And finally, we have limited options under a retributivist approach to punishment. And so often the punishment would be incarceration. What does this look like in application, right? Retributivism promotes uniformity. So whereas we saw in utilitarianism, we can have a broad range of sentences based on the individual or the particular facts of the case. In retributivist approaches, we are fairly uniform. If you committed a particular crime and you're morally culpable, you are likely to receive the same sentence across the board. We also use determinate sentences. Rather than saying 0 to 5 years, we say that the particular sentence for a particular crime is set at 2 years or 5 years or life. And then again, we are basing the sentence on the instant offense, not past offending, not potential for future offending. It is what is the individual convicted of at present. And again, we are looking at few or limited options. So again, mostly we're looking at incarceration. But we could have, under a more modern system, other types of sentences. But again, we would be looking for a uniformity and a determinate sentence. Okay, so before we move into looking at punishment and application, just recall the videos you would have looked at for the overview of sentencing, and as well some of the basic information in the notes and the reading, that we implement punishment theory through sentencing systems and processes that are set out by legislatures, right? So legislatures enact crimes, they enact offenses, and they set punishments for conviction. As well, they set out the punishment procedures. So what are the particular sentences that can be imposed? Who has authority to impose those sentences? All right, so ideally, a jurisdiction's sentencing structure is consistent with either utilitarian or retributive principles or both. It is not always clear, however, which principles are guiding the decision making. Oftentimes, we have a hybrid model, one that embraces both retributivist or utilitarian principles. Okay, so take a look at the next slide, which brings us into punishment in practice and the material in the reading. And here we have two cases, Dudley and Dew. Dudley is a very old case and Dew is a much more modern case. They are two very different cases, but through these cases we can explore punishment in practice, concretely. How might we think about punishing particular individuals? Do we treat them the same or differently? And what is the legislative function with respect to establishing punishment, and what is the judicial function? So in Dudley, we can take a look at punishing a collection of individuals within the same factual scenario. All right, in contrast to the Dew case where we have one single actor or defendant. So we can compare in the Dudley case how we might treat Captain Dudley versus his first mate, Stevens, right, or Brooks, who is the able-bodied seaman, so to speak. So this is an English maritime cannibalism case from the 1800s, and here the defendants, Dudley, Stevens, and Brooks, have been charged with homicide and for the killing of a young boy, Parker. Sorry, let me just clarify. Dudley and Stevens were charged, and the question we can take up is whether Brooks also should have been charged. Excuse me. So this is a potential circumstance in which we can consider the culpability of Dudley and Stevens as well as Brooks for the killing of Parker. So on your own time, you can think about the actus rea, the mens rea for each of these gentlemen, Dudley and Stevens and Brooks. What is it that each of them did to promote or facilitate the killing? What was their mindset in doing so? What was their mens rea? Right? But assuming that we could convict each of the individuals, Dudley, Stevens, and Brooks, who was not charged again, the question is, well, what punishment would we impose on them? So if you are representing the defendants in this case, right, well, you might make an argument grounded in utilitarianism or in retributivism. And if you are the government, you might also ground your arguments in utilitarianism or retributivism. And so the questions that I'd like you to ask yourself and talk about amongst yourself or a group of your friends on Twin is whether or not Dudley and Stevens were culpable. Did they do anything wrong, so to speak? Was it necessary for them to kill Parker to survive? Do we need to generally deter others from engaging in homicide in these types of scenarios and cannibalism in these types of scenarios? Do we need to specifically deter these individuals or rehabilitate them? And then from the government's perspective, right? Have they acted morally wrong, right? Have they acted in a way that would result in their conviction and hence they should be punished, right? Do we need to deter individuals generally or specifically? All right. And then finally, you could think about Brooks. Again, we could think about these questions of punishment similarly for Dudley and Stevens and Brooks, but why might the government not have charged Brooks? What might be the government's thinking or reasoning with respect to why Brooks should not have been charged and should not have been subject to punishment? So, just a heads up, in the court's actual ruling, the individuals were convicted. Dudley and Stevens were convicted and they were sentenced to death, but their sentence was commuted by the Crown to 6 months in prison. Next slide. Do helps us look in more modern times at legislatively created punishment, right, and the breadth of judicial sentencing discretion, which becomes a particularly important factor these days when we are talking about sentencing options and sentencing disparities, right? And we'll see it play out in two cases I'm going to um, have you take a look at to ponder. All right, and so in the due case, you have two readings presented, two opinions. The second opinion is the trial judge's sentencing order. The first opinion is the Intermediate Appellate Court's review of that order. So, some points to keep in mind about this case. Judge Carlin presided at the defendant's trial and sentencing, and like the jury, she heard all the evidence and saw all the witnesses, although she was not responsible for returning a verdict. Keep in mind that the defendant was convicted by the jury of voluntary manslaughter, meaning the jury must have found beyond a reasonable doubt that the defendant had the intention to kill her victim and that the killing was neither justified nor excusable. So there were no defenses, including the possibility of self-defense from the jury's perspective. So the jury rejected claims that the killing was either unintentional or committed in self-defense. So after the conviction, Judge Carlin's responsibility was to impose the sentence and more particularly whether or not the defendant should be incarcerated. And so as set out in the opinion, we see that the legislature has set forth several sentencing factors for consideration, including to protect society, punish the defendant, specific deterrence, general deterrence, incapacitation, restitution, and uniformity in sentencing. And so if you think about our brief conversation about punishment theory, you can see that this is a hybrid sentencing scheme, that the legislature has embraced both utilitarian and retributivist principles. The legislature requires the court to adhere to the goals and objectives of the sentencing statute, but does afford the judge discretion to sentence within the guidelines. So in her decision, Judge Carlin pretty handily considered and dismissed four objectives: protect society, specific deterrence, incapacitation, and uniformity in sentencing. And she doesn't consider two factors: general deterrence and victim restitution. So let's take a look for a moment at the factor of punishing the defendant. That's the dispositive factor for Judge Carlin in setting the sentence. And then I'll also ask you to take a look at two other factors: general deterrence and protecting society. So whether or not the defendant needed to be imprisoned as punishment for committing the crime. The legislature here had enacted a presumption against probation because this was a case involving a deadly weapon, a firearm. So there was a presumption against probation because a deadly weapon was involved in the case. That presumption could only be overcome if the sentencing court deemed a case unusual. If the court concludes that the presumption is overcome because the case is unusual, then the court was mandated to sentence the defendant to probation. Here, the judicial sentencing authority or discretion was curbed, but it was not entirely constrained. So in this case, Judge Carlin determines that the presumption was overcome and that probation was warranted. And the reasoning Judge Carlin invokes is that there was great provocation, that the victim assaulted the defendant first with her fists, that the defendant did not have any criminal history, that the defendant wouldn't have shot the victim except for a history of terrorization of the family, that the gun had been altered, and that the defendant wouldn't have been in this situation except that she was working in place of her son. So, one thing for you to grapple with is whether or not the court's conclusion that there was great provocation is consistent or inconsistent with the jury's decision. Recall that the jury's verdict, in effect, concluded that the killing was intentional and not in self-defense. So, on your own or with friends, think about what facts might have led the jury to conclude that the shooting was not in self-defense and was intentional and warranted a voluntary manslaughter conviction. And then think about whether or not Judge Carlin's decision to impose probation is consistent with the jury's verdict or thinking. I'm going to suggest it's not. But keep in mind that the judge heard the same facts as the jury at the same time as the jury. And so she was authorized under the statute to reach this verdict, this decision, and conclude that a sentence of probation was acceptable, that the presumption of imprisonment was overcome. So while Judge Carlin's decision might be inconsistent with the jury's verdict, she was acting within her authority. So this is actually quite a fortunate outcome for the defendant. Judge Carlin sentences her to 6 years incarceration on the voluntary manslaughter charge, 4 years incarceration on the gun charge, but she suspends all of the sentence of imprisonment and imposes a period of probation. So the defendant here receives a double benefit. The government could have charged her with first-degree intentional murder, but instead chose to charge the reduced offense, which results in a lesser sentence. And then Judge Carlin further reduced the sentence from imprisonment to probation. So food for thought is whether or not Judge Carlin could have strengthened her decision, or whether or not the government has a good argument, potentially, about the need to protect society and deter others, right? So on your own or with friends, and let's talk about it on Twin, right? Could there have been an argument that the public needed to be protected as a result of this offense? Should incarceration have been imposed to protect society? And then as well, whether or not general deterrence should have been invoked here. Is there an argument that the defendant should have been incarcerated in order to generally deter others? All right, so could we have made a stronger argument for incarceration based on general deterrence and based on protecting society, two factors that Judge Carlin didn't really consider? All right, so some food for thought regarding a highly well-known and notorious case, right? The notes give you plenty of background. If you're not familiar with this case, they provide a lot of context for the circumstances and the tenor of life in LA at the time of Ms. Du's sentencing, at the time of the defendant's sentencing, right? And ultimately, the outcome, what occurred after Ms. Du was sentenced, after the defendant was sentenced, and in particular, that might inform your thinking about whether or not there was a need to protect society and a need to generally deter. Um, so, given what we see in the Dudley case and in the Dew case about how we can think about punishment from a theoretical perspective, utilitarianism and retributivism, and then how we can think about sentencing authority, right, as set out by the legislature, and then a judge's ability to carry out or have discretion within sentencing. Um, we can consider two scenarios that we've been looking at in the course of the semester. So the Justin Ross Harris hot car case, and then as well Brock Turner sex assault case. So on Twin, I have posted a couple links relating to those cases, more than a couple links. I posted one link to the Justin Ross Harris case. It's a link to a podcast regarding the sentencing. And then I posted several links to the Brock Turner case and the sentencing imposed in that case. And so check out those links on Twin and think about whether or not the sentences imposed in those cases were authorized by the legislatures. In other words, was the judge acting within his or her authority? Were the sentences appropriate in terms of public sentiment about the crimes? Were the sentences appropriate with respect to consistency, how other individuals who may have committed the same crimes would have been or have been treated, or are there disparities? Um, Lots of food for thought in those particular cases. But so let's talk about it on Twin. And then finally, take a look at the last PowerPoint, which raises this question of punishment reform. What's next? Where should legislatures and where should courts go in terms of approaches to punishment? And so I've also posted a few links on Twin for you to look at to think about the future. The first is a link to a video from the American Law Institute, which talks a little bit about its current efforts to reform the Model Penal Code's punishment provisions. And then I've also posted a link on Twin to a conversation about the First Step Act, which, if you're not familiar with it, is a recent federal act to reform punishment in the federal criminal justice system. And the link is to a pro-con discussion about the First Step Act. In other words, was it a good or positive act, or are there some concerns and critiques? Okay, so that's it with respect to our conversation about punishment. This is a little bit of an abstract conversation in some respects because we're thinking about big questions here. We're also looking at punishment theory, but it is also a concrete question because we're trying to then take those big questions as well as punishment theory and actually on the ground see how they're applied in particular cases. And so marinate on the Dudley case and the Dew case, and then as well the Justin Ross Harris case and the Brock Turner case for some of those big questions about punishment and our sentencing approach overall, and then as well, how are we capturing either utilitarianism or retributivism in the punishments that are being imposed in these particular cases. Okay, so that's it with respect to punishment. Take care, and we'll